SJC-10313, DiFiore versus American Airlines.
Good morning, Mr. Sid.
Good morning, Your Honors. May it please the Court, for the plaintiffs, I'm Shannon Liss Reardon. A year ago tomorrow, a group of skycaps proved to a federal jury that American Airlines had redirected to itself tips that for decades passengers had traditionally paid to the skycaps. The skycaps proved to the jury that American's $2 per bag charge was a service charge under the Massachusetts tips law, even though it was not expressly labeled as a tip, gratuity, or service charge, because customers reasonably believed that it would nevertheless...
May I ask, was there a sign or anything that explained what this $2 fee was for?
There was a sign that said American Airlines $2 per bag charge. And at a certain point in small print, the words gratuity not included were added. Evidence was presented at trial that, first of all, customers didn't look at the signs because of the hecticness of the curb.
Did you say?
Did not look at the signs, that the print that said gratuity not included was in small print, and lastly, that even people who saw the sign and looked at it were confused by it. They either didn't know what gratuity meant, or they thought it meant that the $2 per charge went to the skycaps, but if people wanted to add a little extra gratuity, that would be appreciated. Just as when you have a service charge added to a large party or banquet at a restaurant, there's still an opportunity for customers to add a little gratuity on in addition to that.
But surely it was not a problem for American Airlines to charge a fee for curbside service, so long as it was properly described.
And it was a fact issue. The district court properly determined that a fact issue had been created as to whether or not, on the one hand, customers reasonably believed that the charge was a tip or in lieu of a tip for the skycaps, or instead whether or not American had sufficiently informed customers that it was not a tip or service charge.
To come under the exemption.
The administrative fee exemption, exactly. Now, properly speaking, Your Honors, that issue should not be before this court. The question of whether or not the trial court properly determined there to be a genuine issue of material fact on this would be something for the First Circuit Court of Appeals. This court has been brought to it legal issue, a particular legal issue that the district court certified.
Could I just ask you, I'm sorry, another
certainly.
factual question. Was G2, I've got G20 in my head, but it's G2, right?
Yes.
Were they ever defendants in this case?
Yes, they were originally a defendant, but because of an arbitration agreement, the plaintiffs dropped G2 and pursued an arbitration claim against G2. American Airlines imposed the $2 per bag charge. The plaintiffs pressed on this claim against American Airlines because it was American's charge, the sign said American Airlines, it was American's idea, and it was American that profited by redirecting the tips that passengers had traditionally paid.
Didn't it go to G2, though? Except for whatever was over its cost would go to American, but G2 got it initially, correct?
Well, there was
from G2's employees.
There was a formula of division of the percentage that G2 received and the percentage that American received. However, American had, and this gets into facts that I don't think are before this court, but just for the background, American previously had paid G2 to have skycap services. By implementing this $2 charge, American saved itself the cost of having to pay out money to G2. So G2 received its money from the $2 charge. American received a share of the profits as well. So American is the one that profited fully off of the $2 charge.
Can you point to language in the statute that supports your position?
Certainly. American and the district court have focused like a lightning rod on the definition section. All three substantive sections of the statute, sections B, C, and D, all refer to employer or person or other person. The definition section, where the legislature inadvertently, I submit, left out the words or other person from the service charge definition, the legislature protected itself by putting in the preamble to the definition section language that these definitions are to apply unless prescribed for another meaning within the substantive portions of the statute or another meaning is required by context. 3 separate times the legislature emphasized that it referred to employer or other person. Throughout the history of the TIPS law, which has been continuously expanded since its enactment in 1952, the legislature has expanded the breadth of protection for tipped employees.
Mr.
American,
May I, excuse me,
Please finish, and then I didn't know if you were going on to another
Right.
point.
My point is that American is saying that the legislature silently reduced protection by adding a definition section in which it left out the word or other person, despite the fact that all the substantive sections, B and D in particular, which are relevant here, refer to employer or other person. It just simply does not make sense that non-employers would not be liable under the TIPS law when it says repeatedly no employer or other person. And in the only appellate decision to date on the TIPS law, the Cooney versus Compass Group case, we have exactly the situation. A non-employer...
Can I now interrupt you, because
Sorry.
we are not sitting here as an appellate court. We have a simple certified question to us, correct? And notwithstanding the invitation of the federal district court judge to give him advice on any other questions, it seemed to me that doesn't fall squarely within our certification procedure. So confining you to the question presented, which is his interpretation of the statute correct? I take it this is a post-trial interpretation of the statute?
Yes.
And so leaving aside the definitional section, why would one not read the first, the definitional section in the way that he has proposed, namely that there's a two-part analysis?
If pressed, I would agree, if we were to focus only on the definition section, that the district court's division of two categories of service charges makes more sense than American's four-category division. There are two types of service charges. I do not disagree. One are those that are expressly labeled as tips, gratuities, or service charges, and the other category, which is what this whole trial was about, is whether or not, notwithstanding not being so labeled, the charge is something that customers would nevertheless reasonably believe would be given to the service employees as a tip or in lieu of a tip.
So
Now,
one way to look at this is not so much to look at the substantive charges, but to see whether or not the legislature intended that when it comes to non-employers, you have one set of categories, and when it comes to another, when you come to employers, you have a different category.
Right. Well, several reasons why it just simply makes no sense. While I do not disagree with the court that perhaps there are these two different categories, it makes no sense to have non-employers only potentially liable for the closer cases, the harder cases. This would exempt non-employers from the easier cases where charges are called tips, gratuity, or service charges, but make them only potentially liable.
I don't understand. You make that argument, but it seems to me that that's a crazy argument. If it's labeled a tip, why wouldn't someone reasonably expect that it would be given to the wait staff? I mean, doesn't that just answer the question?
Well, Judge Young determined that because he had not instructed the jury about these two different categories, we have to go back and redo the trial for the G2 employed skycaps because we don't know whether or not the jury found that they fell into the first category, i.e. were labeled tips, gratuities, or service charges, or the second category that customers reasonably believed them to be, which really makes no sense because the whole trial was about whether or not customers reasonably believed them to be. But as a policy matter as well...
Is the essence of your argument that Judge Young's interpretation really goes against the entire purpose of the statute?
Yes.
And it boils down to that.
Yes, because under Judge Young's interpretation, there's a blueprint for how companies can avoid the tips law.
Right.
They can contract out employees, and then they can expressly call them tips, gratuities, or service charges.
Ms. Learton, can I just ask you this question? Was there any discussion as to whether or G2 was acting as the agent? Forget about, I mean, I'm trying to think of a situation where you can have a third party, that's not doing the work, a valet service, right? It is not necessary that you come by automobile to a restaurant. It is necessary that you check your bags if you want to get them onto American Airlines, correct? Yes. So if you're going through a G2 G2 employee, are they not acting as an agent? I mean, was that
Yes.
raised in the court?
Yes, well, what was raised is we presented evidence that G2 and American were joint employers, that G2 was essentially acting as an agent for American, and that this whole issue is irrelevant because they were joint employers. Because Judge Young agreed with the plaintiffs during the charge conference that non-employers could be liable just like employers, we didn't request a specific jury instruction on whether or not American and G2 were joint employers. After trial, he decided this distinction was relevant, in which case we would have asked for either an agency or a joint employer instruction or question for the jury.
Could
But-
I'm sorry, finish your answer.
Yes, but the point is that, yes, G2 was essentially acting as an agent for American. The G2 skycaps, there was evidence that they were wearing American insignia. They had American ID badge. In order to check in your bags outside on the curb with American Airlines, you brought it to a G2 skycap.
My question is, even if you take what I take to be Americans' interpretation of the service charge, and all parts of that definition refer back to employer, under B, why isn't American still liable? Because it says no employer or other person shall demand, request, or accept. Well, clearly, I take it under this agreement, it is accepting this the service charge, isn't it?
Yes, exactly. We say that under sections B and D.
I mean, but even accepting you don't even need to read in or other person into the definition. It seems to me you get to the same place, don't you?
I agree, yes. Yes.
If we happen to agree with Judge Young's two-part analysis, it goes back for a trial, and then the issue would be whether or not customers reasonably assume that the money goes in as a tip, and also on the other issue of whether or not American Airlines are employers, right?
Right, but the first part of what you just said, we already had that trial, and we won, and we proved to the jury that customers reasonably believed that it was a tip or in lieu of a tip for the skycaps, because the sign did not say it was a tip, service charge, or
So
gratuity.
then if we agree with Judge Young's interpretation on the second point, you win. Is that what you're saying?
Yes, I mean, essentially, we have argued that it was harmless error, because clearly the jury found that customers reasonably believed that it was a tip, gratuity, or service charge. They could not have found for us under the first category. Judge Young says we have to have a new trial because he doesn't know whether they found for us under the first category, expressly designated, or the second category of what customers reasonably believed. We said it was harmless error, and he denied that motion for reconsideration without comment. That's why we're here.
Is there an entitlement to legal fees?
Excuse me?
Is there an entitlement to legal fees? I just don't recall under the tip statute to the
Yes, there
prevailing
is.
party.
Yes, there is.
Okay.
Now, was there any legislative history about subsection G that indicates that the legislature imagined the possibility of independent contractors coming in to play the role of employees?
I'm not aware of particular legislative history on that point. It seems clear that the legislature, while focused on a number of issues, were not particularly focused on the issue of the contracting out problem, which is why they inadvertently, I believe, didn't include other person into the definition section. However, looking at the Commonwealth's very strong independent contractor misclassification statute, Chapter 149, Section 148B, it really makes no sense that the legislature would have somehow been encouraging companies to be able to evade liability under statutes such as this through the use of contractors. It goes against the legislature's clear purpose in providing maximum protection for employees, for tipped employees, and in preventing companies from avoiding their obligations through contracting.
So how specifically would you ask us to read this statute on the question of service charge? Are you asking us to read or other person, service charge, a fee charged by an employer or other person? Is that what you're asking us to read in there?
Well, what I'm asking the court to do is not to focus exclusively on the definition section, particularly where the definition section says
Then tell
it
us
can be by context.
how we would read any of these other sections.
You read the other sections exactly as they're written. B says no employer or other person shall demand, request, or accept, etc. any payment or deduction from a service charge. Section
Okay,
D.
but a service charge being something charged by an employer.
But it simply does not make sense. By an employer, in a sense, is almost gratuitous language that was thrown into the definition section inadvertently. In B, the substantive section says no employer or other person shall demand, accept, request any payment of any nature from a tip or service charge. It's a tortured reading to say that you have to then go back to the definition of service charge and say that, well, it can't mean an other person is demanding a service charge because other persons can't impose service charges.
they
It's
can
just too
accept
tortured
it.
a reading.
I mean, I agree, they can accept it.
Yes.
Even if G2's the employer, if American is accepting it, it seems to me they fall under B.
Can I just
Yes.
ask this? Again, we're not an appellate court, so I'm not interested in issues of waiver. I'm trying to answer a certified question. With respect to Justice Gantz's question, was there any, did you or the defendant draw subsection G, which seems to me that if you, in addition to Justice Botsford's question, you have American Airlines has a special contract, and that is a means attempting to exempt itself from the section. Why would that not inform how we answer the certified question?
I believe that it would. We've referred in our briefing and throughout this case to the district court that the substantive sections provide for other persons.
I understand
G
that.
is one of those.
Did the district court look at G and say G is not applicable here?
I don't recall whether he specifically focused on G. He focused exclusively on A.
Thank you, Ms. Lislearton.
Thank you.
Good morning, Ms. Mariani.
Good morning, Your Honor. I'm Amy Kishore-Mariani, and I'm here on behalf of American Airlines today asking you to do three things. First, we ask that this court hold that businesses may not be held liable under the Massachusetts tip statute unless two fundamental conditions are met. First, that the business in question is the plaintiff's employer, and secondly, that the business has failed to provide notice that the charge in question is not a tip, gratuity, or service charge.
If that's your interpretation, how do you deal with Section G?
Section G of the statute does not, by definition, prohibit businesses from entering into outsourcing contracts. The legislature certainly was aware of the existence of outsourcing contracts at the time that it entered into this particular iteration of the statute because, as Ms. Lislearton mentioned, it was contemplating at the same time the independent contractor statute. Thusly, I don't view G as being applicable to this
Because
situation.
it's talking about a contract with an employee, not with another employer?
That's correct.
Although it says, or by any other means.
By any other means,
Will you agree with me that what the intent of the statute is that an employee receives tips, the employee should receive those tips, correct?
generally speaking, that is the intent.
So if the employer does something, uses any means, the effect of which is that the employee does not receive the tips, doesn't that fall within G?
The statute defines employer in a very particular way.
Yes,
And
and then it goes on to have a number of substantive provisions.
That's correct. And if you look at the way the statute defines employer, and you look at Section F of the statute, which references 27C, it's clear that employer is meant to be the person who controls, directs, or supervises the activities of the particular employee. It's not meant to address outsourcing situations. As Ms. Lislearton mentioned earlier, if there is a situation where the intent is truly to deceive and truly to avoid
This is
liability.
not an intent statute, though, is it?
I'm sorry, I didn't.
This is not an intent statute.
Correct. It's not an intent statute, but I think if you look at the provisions of the statute in connection with the independent contractor statute, if there's evidence of really joint employment, if the company assessing the fee is truly directing the operation and is truly...
You mean American Airlines is not directing the pickup of the bags at its
People are
terminal?
wearing insignia?
They do not wear American Airlines insignia. These are
Did they at the
G2
time?
employees. Excuse me?
Did they at the time?
No, they did not.
Are they operating at an American, the outdoor a counter that says American Airlines check bags here?
They are operating at American Airlines curbside.
And if
Presumably,
I-
they're operating under directives and procedures set by American Airlines, since American Airlines is going to be responsible for the handling of those bags.
The bulk of the procedures and policies are set by the TSA and Massport, and those parameters are communicated by American Airlines to G2.
Is there any question that if I fly on American Airlines and I give my bags to a G2 person, and if the bags are lost, that I hold American accountable?
Under the terms and conditions of carriage, American would be the liable
Absolutely.
liable party.
Could
So
I
in
ask
this-
you another question? You keep using the term outsourcing. Outsourcing did American Airlines, and I'm just looking at Judge Youngs's order of certification. He says on page 1 that G2 and American split the fee among themselves. Is that correct?
That is correct.
Is that outsourcing?
Yes, it is.
I mean, just if you step back an inch, doesn't this seem like it's a way around the statute?
There are circumstances where there might be a harsh result for certain employees.
Like this one,
And
no?
like this one. However, the legislature is presumed to know what the results of a particular statutory interpretation might be at the time it passes the statute.
Could I ask you, just under Section B,
Certainly.
subsection B, and it's taking your definition of employer, and that the service charge applies only to G2, not to American, why doesn't American fall under B as other person, and therefore would be liable?
Because American does not demand, request, or accept from
It
any,
does accept.
not from any waitstaff employee, service employee, or service bartender.
Oh, please. You mean, they get it, they give it to G2, and that's not from them?
There is no relationship, direct relationship between American Airlines and the G2 employed skycaps, and that's not something that the legislature contemplated, in my view.
But just to be clear, I mean, if you're right, then I could start a restaurant. I could say 15% tip added, and as long as I form a shell corporation, which will be the employer of the servers, I can do that, even though I could not do it if I were to directly employ those servers. Is that basically what you're asking us to say?
Well, is the shell corporation really directing or managing the operation of the employee?
Let's assume that it is.
If it is, then under the way the statute presently reads, that's a possibility, and that's something that the legislature.
Why is
if
that?
this-
Why is that a possibility under your reading?
Because the goal of the statute is to make sure that persons' employers do not interfere with their tips, with
So,
service charges.
Stated differently, it's not an intent question; it's an agency question. Correct?
To a degree, yes.
So, and you're saying that there's nothing in this record that would permit any fact finder to conclude that G2 was an agent of American Airlines?
At this point, the record does not establish that the G2 skycaps have a right to recovery from American Airlines. Do they have a right to recovery from G2, and then G2 can go after American Airlines contractually? Perhaps. But under this iteration of the statute, there is no direct right of recovery from the G2 skycaps.
Was the interpretation that the trial judge came to post-argument, was that raised, was that the interpretation proffered by anybody?
No, that is his interpretation. American has from the outset argued that you need to be an employer and an employer only to be liable for the imposition of a service charge under the statute.
So let me understand this. You've got this desk out there, sign, it says $2 service charge. If G2 had put that up, they clearly would be liable, right?
Unless they had provided notice under the statute, in which case they'd be exempted.
$2 service charge, that's what it says. That's all it says, $2 service charge. They clearly would be liable to the employees. for not paying those service charges to the employees.
Correct, if the proceeds were not turned over.
Same scenario, same sign. But American Airlines has put that sign up, not G2. And American Airlines is insisting that the charge be implemented, not G2. American Airlines not liable.
Not with respect to the G2 employees. However, it is liable with respect to, it could be liable if notice has not been provided to its own employees. And there is one SkyCap, Don DiFiore, who is a direct employee of American Airlines. And thus, it would be incongruous given the fact that there is an administrative fee exemption in the statute available only to employers to allow American Airlines not to be liable to Mr. DiFiore, but to be liable to the G2 SkyCaps.
So that sign could say $2 tip. If American Airlines put it up, $5 tip required. Could say anything. And American Airlines simply would not be liable because these are not their employees. Indeed, it's their desk. Indeed, it's their passengers, not their employees. Is that really possible?
The way the statute is written at present, that's a possibility. However, it would be liable to its own employee. And thus, we have a situation where the statute creates...
Even though other persons, in addition to the employer, other persons are liable essentially for taking the tips that belong to employees.
For taking tips. If you look at, actually, let me correct...
Didn't American Airlines take some of the tips here?
No. Let me correct my previous answer because there would be liability under the statute for another person who takes a tip, which is also defined to be a gratuity. If you look at the way the statute is constructed...
No, I understand that. But American Airlines, we just said, has got this sign, $5 tips. $5 service charge. There's the same thing under the statute.
Actually, the statute does make a distinction between tip or gratuity and service charge. So if American Airlines...
What Mr. DiFiore collected, I think this is Justice Coyle's question, American Airlines, he gave it to them at the end of every day.
That's correct. But if American Airlines had posted a sign that said $2 tip, $2 gratuity, there would be liability on the part of American Airlines to the G2 SkyCaps because of the terms and definitions contained herein.
Now, am I correct that all of the SkyCaps at the end of the day gave all of the money to American Airlines?
No. At the end of the day, Mr. DiFiore handed in whatever $2 proceeds he received to American Airlines. At the end of the day, the G2 SkyCaps handed the proceeds in to G2. And at the end of the month, there was a reconciliation process between G2 and American Airlines whereby G2 turned over a certain portion of the proceeds to American Airlines after taking its expenses and its percentage share of the proceeds.
Counsel, your sister tells us that on the question of whether or not patrons or consumers reasonably expected that $2 would go to the red caps, that's already been resolved below. Do you agree with that?
I do not agree with that because the American takes issue not only with the jury instructions that Judge Young gave with respect to the definition of service charge, but also with respect to a number of the other jury instructions he gave. We don't believe that the jury was afforded an opportunity to adequately address that particular issue. There were no questions on the jury verdict form from which we can ascertain the manner in which the jury came to the conclusion that it reached. So that issue should be retried.
Ms. Mariani, I have a different procedural question. I recognize in some respects the breadth of the federal judge's invitation, but this is surely not an appropriate way to resolve the retroactive application of treble damages or the class certification. I mean, he specifically says in his order the case will be administratively closed and stayed except with regard to any class certification. I mean, are we just to troll through this entire record and figure out what issues we want to solve?
There are discrete legal issues with respect to the retroactivity issue. I would be very pleased to see the court also put to rest for once, as I believe it did implicitly in Salvis, the issue of whether Rule 23 applies to class actions asserted under the wage and hour laws. But they are pure legal issues that would assist, I think, in resolution of this particular dispute. And if the court wishes to address them, the parties would be delighted to see that occur. Obviously, Judge Young's primary focus is on what the definition of service charge is, and if the court believes that it's appropriate to limit its inquiry to that, the parties certainly respect that decision.
I don't recall off the top of my head, but do any of the amicus briefs deal with class certification?
Yes, they do. Actually, the amicus briefs submitted by New England Legal Foundation and to some extent the American Air Transport Association's brief does as well. And then there was a brief filed on Friday at about 4 o'clock by some amicus supporting the position of the SkyCaps, also addressed primarily to the class action issue as well.
What do you say is the consequence of that first provision in subparagraph A, which expressly gives some flexibility to the definitions that are described below? It says, unless a different meaning is required by the context or is specifically prescribed. Did Judge Young consider whether or not that may cause a different meaning to be given to the definition of service charge?
Based on his certification order and his order granting a new trial, it does not appear that those were issues he specifically addressed. However, that language does not alter in context the application of the statute. When you look at the statute, nowhere in the statute is it prescribed that an employer and an employer only be responsible for implementing a service charge. When you look at the statute in context, nowhere is it prescribed that only an employer be liable for implementing a service charge. Rather, there is liability contemplated as to other people by virtue of the definition of employer and by virtue of the fact that others may be liable if they take tips or gratuities. The legislative history behind this statute supports the interpretation afforded by American Airlines. Contrary to the SkyCaps assertions, this particular statute did consider and contemplate the needs of businesses as well as employees. And if you look carefully at the 3 iterations of the bill preceding the statute's enactment, it becomes very clear as well from the AG's testimony and from the advisory. Thank you very much.
Can I ask you a question? That the appeals court case, I can't remember the name of it, involving Northeastern.
Cooney versus
Cooney.
Cumberland.
Is that wrongly decided?
First of all, it was decided under a previous iteration of the statute that did not contain any of the definitions that are at issue here in this case. Secondly,
But the facts seem quite the same.
the facts are similar insofar as we're dealing with a business that outsources certain functions and services.
And the business charges a service charge to people who come to have dinner at the facility.
Which was described as such, and that's a material distinction because American never described the $2 per bag fee as a service charge.
I'm sorry, what did it just describe it as?
It was just described as a $2 per bag fee. It was not described as a service charge
That's a
in any way.
factual issue, how you
Actually,
interpret that.
it's contained in the record that's before this court. You have a copy.
No,
of
I understand, but how one interprets that, I understand that's what it was said, but the interpretation that a patron would give to that becomes a factual issue, doesn't it?
So Northeastern was held liable.
Well, Northeastern, in the Northeastern case, actually, the fee in question was defined on the invoice as a service charge. Thus, there was no question in the appeals court's mind that this was a service charge because it was entitled as such. And that, I think, is a material distinction upon which the case turns. There is no description of this particular fee as a service charge, and the facts are therefore distinguishable.
Okay.
Thank you, Ms. Mariani.
Thank you.